Thank you again for your patience, and we apologize for the delay. But let's continue the public testimony. I don't know who is next, but
I'm just going to finish up and then go down the row.
Okay.
I just wanted to speak about one more issue, less than a minute. Thanks to a piece of legislation the Labor Federation introduced last year, AB 1988, the Appeals Board has decided to do an abatement pilot project. When a violation is appealed, there is no abatement required until the appeal is heard. We're very pleased that the Appeals Board has begun this pilot project. I'm a bit concerned over some statements that were made at the last meeting about them not being sure about having staff or resources to continue the pilot project past it being a pilot project. But there's definitely a concern that abatement does not happen when an appeal is being heard. So we'd hope the Appeals Board could find the staff and the resources in these tough, tight times to do that. We think it's a good thing, and it keeps workplaces safer in the long run. And then I'll finish off by just laying out some other issues that other folks may talk about that we have concerns about. Venue issues, the Appeals Board meeting, for example, in the Valley, instead of just West Covina and Sacramento and Oakland. Continuances that are granted to employers and DOSH inspectors for legitimate reasons, lack of continuances. And determining for inspectors and attorneys which cases would be heard first at hearing. So I'll just pass it on down to the next person now.
I'm Laura Joe.
Nice to see you.
Nice to see you. It's been 10 years since I've appeared before a committee chaired by you.
And neither of us have changed.
Neither of us has changed. You look exactly like you did 10 years ago. So I am...
Thank you.
I'm Laura Jofu. I'm the legal director of WorkSafe. It's a nonprofit that dedicates itself on ensuring safe and healthy workplaces in California. I would ask this committee to postpone the nominations, reconfirmation of Mr. Pacheco. There has been a pattern and policy and practice that the Appeals Board, over the 4 years with Mr. Pacheco on the board, that has undermined the law and in protecting workers and are contrary to court cases. Now, the 47 inspectors who wrote the letter to the Appeals Board did not do this lightly, and the issues that they raised are very serious. And I want to just read a sentence or two from that letter. They protest the board's policies and practices that have significantly undermined our ability to do our job in protecting the lives, health, and safety of California workers. The net effect of board policies has been to sabotage the division's ability to defend citations and penalties on appeal. Cal OSHA is forced to fight with one hand tied behind its back. That is very serious allegations. And these allegations have been made over the years. There's been years of frustrations leading to this letter sent June 19th, in June to the Appeals Board. And I will get to the issue of the $5,000 penalty, whether or not there is a culture of settlement. But one of the things I want to point out is at a public hearing on August 6th, where the Appeals Board heard stakeholders, one of the inspectors that wrote this letter said that when 3 to 4 cases are scheduled in a day, they have to sit down with their supervisors and decide which of those cases they would have to sacrifice in order that one case went to hearing. And so these inspectors basically are forced to settle pennies on the dollar in order to do a hearing on one case solidly. And these inspectors said that this practice of multiple hearings in a day, that's why there have been hundreds more settlements over the last 4 years, many with drastic reductions and final penalties. So when I litigated, I settled 90% of my cases before going to trial. It's not unusual to settle 80% or 90% of your cases before going to hearing or going to trial. The question is the quality of those settlements. I did not settle cases in order to reduce my backlog, in order to get the cases off my calendar. I settled those cases because it was in the best interest of my client, and I got the best settlement for them. And so when Senator Cedillo asked that question of whether or not there really is a problem now, where there were 80% settlements in the past, there's 84% settlements today. The question is, what is the quality of those settlements? We have no statistics as to the amount of settlements from those years in the past where there were 80% settlements. And if you were to look at settlements today over the past many years, we have inspectors.
Excuse me, can somebody turn their phone off?
I'm sorry, I have it on vibrate.
Okay.
Go ahead.
The inspectors have already said that they've had to settle hundreds of these cases for pennies on the dollar. Now, there are other problems in terms of just the inefficiency of the scheduling process, not just the multiple hearings, but not scheduling hearings knowing that it's a complex case and it's going to go for more than a day. And so you've got situations where cases are finally completed after 2 or 3 days of hearing. But I'll give you an example in Oakland.
We want to make sure, just give us the example, then go ahead. Then we want to wrap up.
Okay,
we need
all right. Well, the example is Oakland, Shady Drayage. The first day of hearing, Sheedy, Shady Drayage. The first day of hearing was March 4th, 2008. The second day of hearing wasn't until 7 months later, in October of 2008, and the third day of hearing was 10 months after that. With proper scheduling, you would have your case over with in 2 days instead of it rolling over a 2-year period when witnesses may not show up again, when the OSHA inspectors have to relearn their case and spend an enormous amount of time, wasted time, in preparing and re-preparing for cases that should have been finished the day after it was actually scheduled. There have been arbitrary dismissal of cases due to technicalities. And an example is an employer who was cited after a carpenter was killed on the job. The ALJ, the administrative law judge, dismissed the case because the citation used the name of the employer that was on its business card instead of the registered employer. In another case, the employer was issued a citation which was upheld by the administrative law judge. The appeals board, on its own motion, reached down and took the case under reconsideration and dismissed the case. This wasn't even the employer appealing. The appeals board reached down and dismissed the citation because it was issued in the name of Tigert Aggregates instead of the registered legal name. Now, you know, these rules are more onerous than a court of law, and the appeals board and administrative law judge hearings are supposed to be informal. These employers had notice. They were issued a citation, and instead of allowing amendments to the name to conform to proof, these cases are dismissed. In terms of the $5,000 penalty, I disagree with Mr. Pacheco that this is permissive. The statute reads, an employer who violates the subdivision may be assessed a civil penalty of not less than $5,000. That means the subdivision may or it may not assess a penalty. It's either they will or they won't. And when they do, then they have to assess a penalty of no less than $5,000.
Is there appellate precedent? Is there appellate precedent on this question?
Not that I know of, other than the Legislative Council.
Okay, very good. Okay.
So, in conclusion, the Cal OSHA inspectors have complained about this for years. All these series of problems. Mr. Pacheco has been on the appeals board for 4 years. It wasn't until this month, earlier this month, that they actually took action on the multiple hearings and have decided to schedule no more than 2 hearings per day. And this came about after oversight hearings by the Senate Labor Committee, after the Appeals Board reform legislation, AB 1988, was introduced, and after a whole series of public hearings where labor advocates, employers, and inspectors complained. And so we are asking for a postponement of the decision to give time for the to see if the Appeals Board actually makes good on the promises that they have made.
Okay. So what I want to know from the witnesses here, the first 2 have said they come asking for a postponement. I'd like to know what the difference between that and outright opposition is in terms of your position. So let's go to Ms. Guzman first.
Thank you. Martha Guzman with California Rural Legal Assistance Foundation. And I think the biggest difference is that we would like to see if, in fact, there will be some change, in particular for our client community, on the actions and the final settlements taken for the heat cases. And we have quite a few outstanding from 2008. And the record on the previous decisions, where I think, we talked at length about some of those decisions during Candace's confirmation hearing and the oversight hearing, but some of them that got slashed from $13,500 to $250. There are more outstanding cases that we'd like to see that a slashing of a fatality not result in $250, and we simply don't know if the board's going to do that. We don't know if Mr. Pacheco is going to ensure that a slap on the hand is not going to continue for heat deaths. That's one. The second is more on the process, and a lot of these cases, what you see, at least in the notes of the decisions, is that witnesses were no longer available. Witnesses could not attend. And one of the big impediments from being in rural California is that you can't even get to Stockton if you live in Huron. And that's, if you're in L.A., you can get to Huron. You can get to Bakersfield. There's no reason from our perspective that you can't use some public building in Bakersfield to hold some of these hearings. I mean, this is a very basic step, and it hasn't happened yet. And in fact, I hadn't seen the calendar as revised as of today, the calendar you were reviewing. There are additional calendaring sites that have been made in Fresno. That's an improvement. But again, we are still certainly not at a place where we could be anyway supportive of what is still, and I would say, not a culture of settlement. It's a culture of seeing the client, and this came out of Candace's mouth, the client as the employer, really. And that's not what we need here. We need a culture that is balanced, a judicial process that is making sure that all parties are involved. And that takes a little time to change, and we're concerned that we haven't seen the progress that needs to happen. And when you're a part of that culture and you've been there for that long, we're also concerned that you maybe aren't going to be a part of that change.
I haven't, Ms. Guzman, I don't want to overemphasize the issue of this calendaring because it may be, symptomatic of a larger concern that you're raising. But Mr. Pacheco essentially said that as they have planned forward post June 19th, that letter, that they are addressing the calendaring issues by not setting 3 or 4 or 5 cases at a time before a judge. You mentioned the location-related issues. As you have looked at their calendaring for August, for September, for October, if you have looked at it, is there a difference and an improvement in your view or not?
Well, certainly one, just skimming it, because this is the first time I've been able to see that version, that one improvement is that there are now Fresno locations. That is an improvement.
So you haven't had a chance to look at the public but not published, to Senator Steele pointed out to me, the public but not published calendar that we were talking about earlier this afternoon.
Right, but I mean, just to go back to what you said a few minutes ago, is that is one concern, the calendaring issue.
It's
and
one.
The bigger issue, really, from our perspective, is the underlying culture around this current makeup of the board that is allowing for heat fatalities to result in a $250 fine.
How many of those cases?
We have, that's the most egregious case. That was a case in Cepeda Farm Labor, and that was a Huron case. And there was witness issues in that case. And again, that's a perfect example of if you had the hearing in Bakersfield, maybe it'd be different. I don't know. But it certainly wouldn't make all the difference. The other case in the Durant Harvest case, there was a reduction from 1,400 to 300. And again, this was not a fatality, but this was failure to provide water and shade. Could have resulted in many fatalities. And in the case of George Perry and Sons, the fatality there was a slash in half from 7,300 to a little over 3,000.
Okay. Thank you.
Mr. Chairman,
We'll let you respond, Mr. Pacheco.
Okay.
Please, don't worry.
try to remember as I can.
Yes, Senator Oniston.
Not knowing exactly how these numbers are established, I'm assuming that the state inspector goes out and has the authority to cite and fine. Who sets what that fine level is? For example, you said 13,000 or something like that for one heat case. Who set that number?
The DOSH inspector.
So it was one individual, a state employee, who arbitrarily had the power to set that.
No.
Okay, well then then give me the right answer. If it's not the inspector, who is it?
Well, maybe Ms. Schreiber.
Okay,
Can you
Fran
introduce?
Schreiberg, and I'm actually an attorney. I was with Cal OSHA for 4 years, from 1980 to 1984. My job there was to prosecute companies who killed and maimed workers, so I was head of the Bureau of Investigations during that time period, and also worked with...
First of all, I'll just tell you that for you to say that your job is to prosecute companies that kill and maim workers automatically sets my bias against whatever you have to say.
That was the job that I had. I was hired to do that because of my criminal law background. I was brought in because there weren't cases being prosecuted.
Go ahead. I'm looking for an
Go on
answer.
with the testimony,
Okay,
please.
so basically I can just try to explain a little bit the way that
I want to know how the
fines work.
$13,000 figure was set.
The numbers are set based on whether a matter is issued as a serious violation or a general violation. There are maximum fines. You start out with a number, and then it is actually reduced by the size of the employer, the good faith of the employer, and
So
whether
it's not
the
an
employer,
arbitrary number. It comes
It's
from
not.
a
the first number
regulation
is not.
or...
Comes from a statute.
Comes from a statute. The first number comes from a statute.
Yeah, that's what I'm looking for.
And then it is reduced from there to these other sets of numbers. Now, when the matter is settled, it's an interesting process because they sit there with the division sits there with calculators and they try to figure out, well, if we dismiss one of these citations and it's a serious, it'll knock $10,000 off, and if we dismiss a general, it'll only knock $300 off. But if we change it to the good faith here or bad faith there, it'll change these numbers, and then that's what they do to get these numbers.
Okay, you've answered my question.
Okay, so why don't we get into your testimony, please?
Thank you. I actually, just to address the question of postponement versus opposition, I mean, I'm somewhere in the middle. I think that the issue of postponing is something that relates to an invitation that the OSHA Appeals Board asked of us, which was to submit some changes in proposed regulations, which we are willing to do, which I am willing to do on a number of the issues that have been raised.
How long will it take?
I'm perfectly willing to do those very shortly. I don't know how long the board will take, and I think that's part of what this committee would have to look at is whether this board were to drag out the regulatory change process. If it did, I think that would be an indication of the fact that they weren't going to
Mr. Pacheco,
be
is
very
that January
positive.
15th of 2010. So as you talk about trying to come to some understanding on amended regulations, time frame matters, both from your end and then also from Mr. Pacheco and the board's end if we were to sort of go down that route. So.
And I understand that.
Okay, so go ahead, your concerns.
So my concerns really do also go, as Ms. Guzman was saying, to the culture. And I think that one of the problems is that this board doesn't see their job as a administrative agency that is bound to actually protect worker health and safety, but sees itself as some kind of independent court. And they're not exactly a court. They are part of an administrative law system, and they have to be seen in that viewpoint. So that what they've done is that there are several different issues that they've come to where they very narrowly interpret a regulation, and when they need to, they simply ignore what the regulation says in order to have an outcome that is essentially not in the interest of health and safety. So the examples that I have of that are a case that involves a multi-employer where they, again, reached down without an appeal being lodged, took an administrative law judge decision on multi-employer, which is one of the most important laws that I think we passed, and it was a struggle, and it was also in AB 1127, as you'll remember. And they reached down and they took this case, and what they did was, instead of just making a decision based on the facts, which they could have done, they decided to change the law, and they shifted the law so that the burden is now on the division to come forward with certain kinds of evidence, which is, number one, contradicts a actual district court of appeal case, and number two, contradicts the statute, number three, contradicts the regulation. So they did this in a way to make it more difficult for the division to prosecute these cases. So that's issue number one. Another example of, I think, something of concern, and again, it comes from my background doing the criminal cases, and now I'm going to speak for both the defendant and the plaintiffs in these cases, is that there have been cases that where the issue of continuances while a criminal case is pending have not been granted. There is a law that requires a continuance if the Bureau of Investigations, which is the criminal investigation arm in Kalush, if they're still investigating a case. However, once that case goes to the district attorney, all bets are off. And in fact, in the PowerPoint presentation that they did at the program on August 6th, that was listed as one of the reasons for denying a continuance. So it was just flat out there. It was a policy decision that they were making. My concern is two things. Number one, they want the division to put its entire case on in the administrative hearing while the district attorney is getting this case ready to prosecute. That shows the entire case. At that point, if the folks who are on the defense side come forward and they assert the Fifth Amendment, then that's the end of the case. They've heard all of the discovery from the prosecutor's side, and they can walk at that point and wait for the criminal case to go forward. On the other side, just having to assert a Fifth Amendment right is a disadvantage for the defendant. I was a public defender for 6 years before I was a prosecutor in these kinds of cases. Those assertions of Fifth Amendment rights can be held against the defendant. So it is equally bad for both parties in these cases to do that.
So,
and this is a policy.
So they're forcing the hearing even if there's a pending criminal case?
That's correct. Their theory is that unless that you won't know that the person, that either the employer or one of the employer's witnesses is going to assert the Fifth Amendment until they do it.
Okay.
Even if they say they're going to do it.
What else?
Okay. So another thing that is of concern to me is as a lawyer who represents victims, and we do, and I'm handling a case right now helping the family of the UCLA young lady who was killed in a lab fire in December, and the family is not permitted, once a person dies, to be a party in the case, and that's because the victim is dead. If the victim had lived, then she could be represented by a lawyer or her union, and she could participate as a full party in the case, and she would have an opportunity to help Kalush prosecute the case by presenting evidence, by cross-examining, and by getting involved in the case itself. However, Mr. Lancaster is not here today. He's actually in trial, and I'm kind of expressing some of his concerns, but they're my concerns as well, that these cases they're saying, okay, you can be an intervener, but an intervener doesn't have the same rights as a party to these cases. So I'm concerned about
So
that
that's
as
another.
well.
And is that a
Yeah.
regulation issue, or is that just a discretion?
I think it's a discretion issue.
All right,
There is a regulation about what's a party and what's an intervener. Party says.
So just to summarize, if I may, in terms of
Yeah.
the culture, because I know I have to get going at 6 here tonight to get downstairs on other subjects, but you complain about the culture relating to the way that the heat-related cases are being dealt with. We've heard a lot about the calendaring, which really the concern is that the calendaring is done in such a way that the case cannot be adequate. A lot of cases cannot be adequately prosecuted. We talked about the issue of the statutory interpretation around the minimum fine for failure to inform. We've heard about a number of sort of procedural issues that the board positions that the board takes that you believe makes it difficult for the process to work effectively. Mr. Pacheco. Lot to digest here.
That's a mouthful, isn't it?
That's a mouthful.
I'll try to address
go ahead.
From my memory as best I can. Obviously, we have 4 people providing information.
That's all right. And
let me tell you one thing that probably bothers me more than anything else is the idea that I, as a member of the board, am undermining the law. Let me tell you, I take my role as an attorney, and I think you've known me here in the legislature for a long time. I do not do that. What I rule upon is what I believe to be a correct interpretation of the law. There are remedies for anyone who feels that we have made a wrong decision.
Can we stipulate here, so we really that everybody is in good faith here? I know you. You're a good person. You're a person of good faith. You approach issues seriously in the way you think. I don't want to go there. I want to get right into the issues. They believe that this is a board that is too business friendly and that it doesn't protect the worker. Your response to that, and then your response to some of the specifics, I think, is what we want to hear.
I'd be happy to address all those. The area of, I think they look at it as sabotaging appeals, which is kind of hard to understand. It's you can throw all these things out, but without any statistics, any information really to support them, it's difficult to know what they're talking about. However, when you're talking about degrading the division, or I should say from permitting the division not to present their case and therefore causing settlements, that's kind of degrading to the division. You think about it. These folks are out there doing a job. Then that question was asked in the stakeholder meeting. And that's why Mr. Carter, the new labor appointee, he asked the people in the audience, how many of you believe that you are being forced to settle these cases, and why are you settling the cases if you do not honestly believe it's the right decision? There wasn't a soul that said, yeah, we're settling the cases because we're being forced. The point is this, and I gave you the statistics already. The settlement percentages are essentially the same. For them to throw out all these numbers without any substantiation is not supported by the percentages. The reductions in the amount of penalties actually finally assessed against the employer. I heard that the first time, and I thought, that seems kind of crazy. So I took one, and I didn't bring it with me. I'll provide it to you. I took one board meeting, and I took all the stipulations where there have been settlements reached. Of the stipulations, the settlement ratio, the settlements amounted, and I'm going from memory now, $356,000 reduction in penalties. The reduction by the ALJs was something like $35,000. These division employees have the authority when they resolve a case, when they actually cite a case and go and speak to the employer, and they then discover that their citation wasn't exactly right the way they looked at it the first time. They have the authority to make changes in the total amount of the penalty. By the time we get them, the only ones that the board actually, and that board being the ALJ who's hearing the case, by the time they get to change or reduce the penalty, it would be only because the parties could not reach an agreement. So any penalty reductions that we've been talking about here, the bulk of them come from the division's reductions, not the board. And we have actually some statistics on that information, and that it's interesting to note that most reductions come because the divisions either feels they can't prove their case, they don't have enough evidence, for a number of reasons.
Or there are too many cases scheduled on a given day, and they can't, they don't feel they can give adequate time to the prosecution.
And like I say, we can assume that, but the percentages don't show it. So, I mean, we can say that, but I don't know that statistically it can be justified. Now, there's a discussion about us not following the law on multi-employer. It's kind of like, fighting me with both hands behind my back. That is a pending case. It's before the appellate court. I can't discuss it. I can't tell you what's right or wrong. We issued an opinion. We issued a decision. All the parties have the right to file a petition, a writ, and get the Superior Court to judge on it. And that's what they have done, and that's what they're doing now.
But you obviously have an interpretation based upon the ruling.
We did on the ruling, and it's there before.
But so you could respond to that. I mean, it's
no, I can't because it's still pending before the appeals, before on the writ.
Okay.
So I can't discuss it. The continuance while a criminal case is pending, you need to have all of the facts. If you had a case that had been pending for a number of years and you keep hearing, we need to continue it again, we need to continue it again, we need to continue it again, and the district attorney is not pursuing the prosecution of the case, and yet the OSHA board has to consider the safety of the employees, abatement, any of these other issues that are important for the safety of employees. So what should we do? So we allow the district attorney to continue to delay the case, or should we proceed?
Well, that's an issue. And that's a different fact scenario than was just presented by Schreiber. So
that's right. But I'm just saying, every circumstance, that everything that was told to you there's a contra story.
Which leads, Mr. Pacheco, let me, if I may. Your nomination expires the 15th of January. And so I suppose that's good and bad from your perspective, in the sense that I do think that period of time gives us a chance to continue talking here. I am not against you. I'm trying to be thoughtful about this, and what's most significant to me is this issue that is hard to quantify, but is really the essence of it. What is the culture of the board? Is it a board that sees its role as protecting workers, or is it a board that sees itself in a different way? And hold on.
Okay.
And though you may have disagreements on individual cases with these four advocates, they're all thoughtful people, just as you're a thoughtful person, who do their work very diligently. I know them all. Okay. And so I'd like to take a little bit more time here and see if there might be a meeting of the minds in terms of some of these questions. And you're not going to change each other's philosophies of life or philosophies of politics necessarily. But there are specific things, and Ms. Guzman mentioned, okay, how are we going to deal with heat-related fatalities? That just sort of like screams as a top priority here. How are you going to institutionalize the sorts of calendaring changes that you say you made? And I believe you. No one's had a chance to sort of check the calendars, but I think a little bit more time might give a little bit more comfort too. If you have disputes about the multi-employer rule, right or wrong, that may be philosophical. I wrote the bill. I know I have my opinion on it, but okay, that's up in the appellate court. The issue of knocking down fines is an issue that I think bears some more discussion. I know the Ledge Council has opined that $5,000 is in fact the minimum fine in the cases we have been discussing. And so, not that you'll agree on everything, and that won't be the test of whether or not I support your confirmation in the end. But I do think to really not be defensive about it, but try to listen to some of the concerns we've heard today about heat-related deaths, about the calendaring issue, which it sounds like you're beginning to make the proper adjustments and that you've heard. But I want to give this a little bit more time so that you can continue to meet with them. And I'd say, Ms. Schreiberg, if you have been invited by the board to submit your specific comments for amending regulations, that in fairness to Mr. Pacheco, if his deadline is really, let's not even say January 15th, let's say December 15th, okay? Just give yourself enough time, that you submit your comments in sufficient time so that the board can consider them and act on them prior to December the 15th. That way we can rejoin the conversation and determine, not perfection, you're not going to get this man to be somebody who he's not, nor should he be. He was appointed by a governor. He's a Republican assemblyman. He has a philosophy. That's okay. But the question is whether or not you can meet a little bit more towards the middle here when it comes to some of the more significant concerns that you have heard raised today. So I'd like to put this over so that we can, so that you can have that shot. He can respond, and we can and we can see if we can really improve the level of confidence of this board, hopefully with you on it, to do, an even better job than the job you say you're doing. That would be my intent.
Well, certainly the call is yours, and so be happy to go with whatever you decide. I do want to say one thing that, and it does hinge on the whole thing, and because although we talk about philosophy, and there's a discussion here about a culture of some kind of philosophy, it does seem to keep saying, in the sense that we are favoring one side over the other. I just want to give you one, for instance, that kind of tells you why it's incorrect. Because there was a lot of discussion about continuances being granted to employers or DOSH being requested. And this is a very quick statistic. DOSH requested 25, there were 25 continuance requests for DOSH. 12 were granted, 11 were denied.
I'm sorry, 12?
12 were granted, 11 were denied. The employer requested, there were 73 requests by the employer for continuances. We granted 30 and denied 37 of them. And then there are other requests. But I just want to give you an idea that we're dealing with this pretty straightforward and honestly. And the numbers don't substantiate what's being said. But being the case, we will provide, understand, we're a very small board, and our budget is very small, right. But we will provide, we have to hand calculate all these things.
I want you to, the burden to me, to be honest with you, is on the advocates here. to provide, to continue what you've done, to provide suggested amended regulations that address some of the things we have heard here today, and then we'll let the board respond to that, and we can then evaluate that. All right?
Okay.
Thank you very much.
Thank you.
Thank you very much. Okay, very good. A couple of things here as we move to item 2. I want to take off the calendar Joseph Tavaglione as a member of the California Transportation Commission. Without objection, continue that to another hearing. I understand, is it true, Mr. Dutton, that you want to continue Grant E. D'Estache?
Yes, sir.
To another hearing. There's no deadline issue on Mr. D'Estache? Not immediately. That's
also Monica Hunter, too.
and Monica Hunter.
Oh, I just want to abstain on her.
So we'll separate that one. We're gonna continue Joseph Tavaglione and Grant D'Estache. And we will then take up 2D D through K, and we'll take up L separately, okay? Moved by D through K with the exception of G and J. Okay. Moved by Senator Cedillo. Please call the roll.
Senator Cedillo?
Aye.
Cedillo, aye. Dutton?
Aye.
Dutton, aye. Oropeza? Aye. Oropeza, aye. Honested?
Aye.
Honested, aye. Steinberg?
Aye.
Steinberg, aye.
Okay, very good. That passes. Now let's take up L, Monica S. Hunter.
Senator Cedillo? Cedillo, aye. Dutton? Oropeza? Aye. Oropeza, aye. Honested? Steinberg?
Aye.
Steinberg.
Passes 3-0. Okay, we're pulling items 3 and 5. Do I have a motion on items 4, 6, and 7? Moved by Senator Oropeza on 4, 6, and 7. Any problems, you guys?
7 were
Okay, so I'm sorry. Then we'll take 4 and 6. 4 and 6. Moved by Senator Oropeza.
I'm going to abstain on 4.
Okay, so let's take them up one at a time. File item 4. Go ahead.
Senator Cedillo?
Aye.
Cedillo, aye. Dutton? Oropeza? Honested?
Aye.
Honested, aye. Oropeza, aye. Steinberg?
Aye.
Steinberg, aye.
That measure passes. Item 6. Capital correspondence request to approve press credentials.
Senator Cedillo? Cedillo, aye. Dutton? Dutton, aye. Oropeza? Oropeza, aye. Honested?
Aye.
Honested, aye. Steinberg?
Aye.
Steinberg, aye.
Interesting First Amendment issue. Okay, file item 7.
Senator Cedillo? Cedillo, aye. Dutton? Oropeza? Aye. Oropeza, aye. Honested?
No.
Honested, no. Steinberg?
Aye.
Steinberg, aye.
All right, before we adjourn, that passes. It is my understanding that the administration this afternoon informed us that it is withdrawing the nomination of James G. Gilmetti as a member of the California Transportation Commission. Is that right? Yeah. Okay, so I want to announce the administration withdrew the nomination of James Gilmetti as a member of the California Transportation Commission. I think I know why they did that, and I don't think that it. I think Jim Gilmetti is an outstanding Californian, an outstanding straight down the middle representative here of the Transportation Commission. And so I think it is unfortunate that the administration chose to withdraw him. So I know that as the Senate Pro Tem, I have the opportunity to recommend to the Rules Committee a Senate nominee for the California Transportation Commission. And I would like to nominate James Gilmetti of San Francisco as a member of this commission as the Senate representative. Is there a motion? Moved by Senator Cedillo. Please, any questions?
I just want to make one comment.
Yes.
You know, somebody who worked really hard on the transportation bond and so forth, Jim was extremely valuable in that process, and it would be a shame to lose institutional knowledge about what everything was and what everything was agreed to. So I'm going to support this nomination, and it's because I feel it's in the best interest to make sure that 1B continues to get implemented the way it was intended.
Very good. Please call the roll. Senator Cedillo. Of course.
People have worked with Mr. Gilmetti. He's an incredible Californian and American, but one who really works. We deal with a lot of issues here, trying to seek a balance between the business community and the environmental community, and he's one who has a particular talent and extraordinary ability to help us reach a lot of resolutions to a lot of challenging problems of the state, and deserves to be on the board, and we would all benefit from his presence.
Very good. Please call the roll.
Senator Cedillo.
Aye.
Cedillo, aye. Dutton.
Aye.
Dutton, aye. Oropesa. Aye. Oropesa, aye. Onnested. Steinberg.
Aye.
Steinberg, aye.
That measure passes. Mr. Gilmetti is once again, after a short lapse of time, a member of the California Transportation Commission. We can do the walk-ons later.
Yes, and
Okay.
then we'll do executive session.
We have executive session right now.
Yes, these three.
Okay, we got to go into executive session. We do the walk-ons on Friday.
Do the executive session.
We can do that on Friday
Okay.
too. Okay, we will skip the executive session and we will stand in adjournment. Thank you very much.